Assalamu alaikum. My name is Ahmed Ibrahim, and today the topic I am going to discuss is investment arbitration. Basically, investment arbitration is a legal mechanism used to resolve disputes between foreign investors and the host states. These disputes often arise when investors believe that their rights under the international treaties have been violated. For instance, if a government unfairly seizes their assets or changes laws that harm their businesses. This process is built on the three pillars. The first is the investor protection, neutral decision making, and enforceable awards. In other words, it ensures that investors are treated fairly, disputes are judged by the impartial tribunals, and that the final decisions can actually be enforced. The next is bilateral investment treaties and multilateral investment treaties. Bilateral investment treaties are the agreements between the two countries. They establish rules and protections for the investors from one country operating in the other. And the next is the multilateral investment treaties. Multilateral investment treaties involve multiple countries and offer similar protections on a broader scale. These treaties are the legal foundation of the investment arbitration. Without them, investors would be left or rely solely on the domestic courts of the host states, which may not always be independent or fair. The next, we will discuss about the arbitration process. The first step is the notice of the arbitration. The investor officially notifies the state of their intention to begin arbitration proceedings. The next is the formation of the tribunal. Both the investors and the state appoint arbitrators. These individuals make up the tribunal that will hear and decide the case. The third is hearings and evidence. Each side presents its case, submits documents, and argues its position before the tribunal. The fourth is the final award. After reviewing all the evidence, the tribunal issues a binding decision known as the award, which settles the dispute. The next is the key players. There are the three major players in every investment arbitration case. The first is the investors, usually foreign companies or the individuals seeking to protect their investments abroad. The second is the states. These are the host countries that may be accused of violating investment protections. And the third is the arbitral institutions. These as ICSID, UNCITRAL, and the ICC. These institutions help manage the arbitration process and provide the rules and support to ensure the fairness. The next is the common claims in the investment arbitration. One of the most common is the expropriation. This occurs when a state seizes or nationalizes a foreign investor's assets without the fair compensation. Another key claim is fair and equitable treatment or FET. This means that states must treat investors in the transparent, non arbitrary way and respect their legitimate expectations. Other frequent claims include the denial of the justice, discrimination, and the restriction on the transferring funds. The next, we will talk about the landmark cases and the trends. Some landmark cases have defined the landscape of the investment arbitration. For example, CMS versus Argentina, which dealt with the economic crisis and regulatory changes. Philip Morris versus Uruguay, a public health case involving our tobacco regulations. These cases reflect an emerging trend. More and more tribunals are scrutinizing how state regulations impact both public welfare and the investor rights. The next we will talk about the challenges in the investment arbitration. First, there is a lack of transparency. Many arbitration proceedings are confidential, which can lead to the accountability concerns. Second, there is the issue of the inconsistent awards. Different tribunals may interpret similar treaty provisions in conflicting ways, which makes outcomes unpredictable. Critics also point to the potential conflicts of the interest among the arbitrators and the perception that the system sometimes favor the investors over the states, especially developing ones. The next is the future of the investment arbitration. Many countries and the institutions are working to improve transparency, consistency, and the fairness in the arbitration. Some are exploring alternative dispute resolution methods like mediation and the negotiation. Others advocate for standing investment courts, which would offer more structure and predictability than ad hoc tribunals. The next is the conclusion, that is the navigation complexity. Investment arbitration is a critical tool in global economic governance. It balances the rights of the foreign investors with the sovereign right of the states to regulate in the public interest. But it's also a field in flux facing pressure to become more transparent, more just, and more aligned with the global priorities like environmental protections